Frison, and I have the pleasure of serving on the board of this fine organization, and it's just getting better and better as we go along. So these two folks here work so hard. So I appreciate y'all and the things that you do for people in this community in particular. I just turned 54 maybe 3 weeks ago. And yeah, I mean, well, it happens to the best of us, right? If we're lucky, it's going to happen to you. It's better than the alternative. So I embrace it. Anybody in here in perfect physical health? Just no problems at all? Coasting? No, nobody. Okay. Anybody in perfect mental health? Anybody who consider themselves just no mental health issues ever, just coasting through life? It's hard. I don't know anyone like that. I don't know anyone like that who has no health problems, either mental or physical. I don't know that it exists. And in thinking about being here with you all today, I was thinking about the many factors that affect our mental health. To me, I would say, particularly in the past several years, it's become so clear to me how much just being black in the United States affects my mental health. And I don't talk to you all every day to know, but I can imagine, based on my experience, what you feel like when you see the things that we see happening in our communities that are all over the country and all over the world. I am a retired judge from the Superior Court of Massachusetts. I just retired a few months ago. So I started judging when I was 39, and at that point I was on the Boston Municipal Court. So you may have seen me in any division of the Boston Municipal Court, but Roxbury was my home court, but I sat in Dorchester, Roxbury, East Boston, South Boston, Charlestown, downtown, Brighton. I sat everywhere. So after about 4 years on that court, I applied and was appointed again by Deval Patrick, our former governor, to the Superior Court, where I just retired from. I saw some people in here today that I'd seen in court before, and some of you may know me from the organization, from court. Some of you may not know me at all. That's great. But I'm known in Massachusetts, but I'm originally from Chicago. So anybody from Chicago, it's still the best city. Still the best city. I am also a United States Marine. I usually introduce myself that way first because I was a Marine before I was a lawyer, but just by about a year. So I joined the Marine Corps while I was in law school and started my legal career as a judge advocate. So I spent time in North Carolina. Anybody spent time down at Lejeune or New River down in Jacksonville, North Carolina, you know what I'm talking about. I've also served abroad in Okinawa and in Quantico, Virginia, and different places in the judge advocate capacity. My last stint on the bench here in Massachusetts, I was in Middlesex County. So you may have seen me in Woburn or seen some cases that I handled in Woburn. And I just want to talk about some of the ways in which I have intersected with mental health issues and had to make decisions about folks who are before me based on mental health considerations. And one of them was my very last case that I heard while at Middlesex. We have in Massachusetts tried pretty hard to reform our criminal justice system. So you may have known about what's called the Criminal Justice Act from 2018. And that act covers a lot of things, but one of the things it covers is solitary confinement. And of course, my role on the bench, as it was, I could not direct how anyone is confined. I could direct whether someone is confined. But the terms of confinement, I found myself having very little control over, even when asked to exert some control. the system of corrections institutions are really little worlds unto themselves, and they connect sometimes with the criminal justice system, but it takes effort on the part of people who are confined to make that happen. And one of those cases came before me, and I wanted to make sure that I heard it before I left. We rescheduled it and rescheduled it and rescheduled it for a bunch of different reasons. But finally, I think literally on my last day sitting, I heard a case stemming from Susan Baranowski from Shirley. And it was a group of prisoners who had filed suit against the department because of the terms of their confinement in what they call the BAU, Behavioral Assessment Unit. And this unit has been essentially operating as a solitary confinement type of segregation. And some folks know about it. And these particular gentlemen came before me with an injunction request, which is sort of right at the beginning of their lawsuit. And if you do know me, you may know that I was always kind of fighting with the Department of Corrections because of prisoner cases. And if you have any interaction with prisoner cases, you know that most judges don't quite take them that seriously. They don't quite give them the attention that they might give regular, what they call regular civil cases with two parties who are not confined suing each other. That was not my approach, and cases particularly like this, where the Constitution is even implicated, I took very seriously. And I don't think the department was ready that day for the hearing. We had to wait a long time before they could get the gentleman in a room with a good connection, and I took a break and had to sort of put them in a room with even at least a telephone so that I could hear them. That took a while. And then once we got on the call, it was very clear to me that the department thought this was going to be open and shut, nothing to see here, folks. And it was not like that. And my decision on the injunction was to allow it after they were both heard, both sides were heard, and to allow it because I felt that the terms of the confinement that they were complaining about was solitary confinement and was in violation of the rules that are now in place about solitary confinement, which, as you know, greatly reduce how much the prison can use it and how often it has to be reviewed and the conditions of that segregation, right? So these are things that are beneficial to the person confined that the prisons often are not willing to enact even after the law is passed, and will fight the courts on even after the law is passed. And so this was my last fight before literally taking off the road. And I issued the injunction, ordered them to release all of the prisoners in that unit and any others who were in solitary conditions whose review of that punishment, as I called it, hadn't been in compliance with the statute. The next day, they asked me to reconsider and told me they were appealing me, which of course they are, and that I hadn't been clear and I hadn't been, didn't address the issues properly, and it was basically nonsensical in my ruling. So I made it clearer for them, because I can be clear, and maintain that position. That is how I left it. It is now being appealed, and now other organizations have come aboard in sort of an amicus function and written briefs that are much longer than what I was able to write about the situation, and they are being held to the standard. I don't think it is done yet, but from what I've seen so far in the appellate papers, it's not what the institution thought was going to happen. And so why does that relate to this? One of the reasons, of course, that we took so much time as a state, as a Commonwealth, the legislature, to address solitary confinement is because of the mental health effects of this sort of barbaric, in the whole type of confinement that we've subjected people to because they are serving a sentence and because something perhaps happens while they're serving that sentence. That is one of the things that act back in 2018 was meant to address. And here I am in 2024 still fighting with an institution about doing the right thing and making those changes and not trying to just change the name of the confinement and pull the wool over everyone's eyes. And one of those, the main motivations for the legislature has been all of the research. And you didn't have to really do scientific research to know what could be the effects of keeping people in a situation that is akin to torture. The reasons that we hold and coddle and kiss and hug babies is because they can actually die if they don't get attention from another human being in the early stages of life. You don't have to be a doctor to know that, and you don't have to be a doctor to know some, at least, of the ill effects of what used to be just flat out solitary confinement for extended periods of time. And if anyone in here has suffered that, you can talk about it much, much more than I can. But on the judicial end, I considered it my duty to impact that system as much as I could to actually make the changes that the legislature has said should be made in those institutions. And that's just one example of things that within the prison system, right, are affecting folks' mental health. Even if you don't have a situation where you are segregated like that, you, just by being in a facility, are suffering from stress and anxiety and witnessing violence and being neglected. Even in the best of prison conditions, that is happening to people. And so these are things that sort of are beyond your interaction or anyone's interaction with the court, but things that it is a progression, and it's all on the same spectrum, starting from your initial entry into any court system. And what's interesting, I don't think people think about that much, is just how much interaction, how much the court has to do with whether or not someone gets treatment, whether or not someone is even assessed for mental health issues, and how much of it rests with the judge, him or herself. So of course, if your lawyer says to a judge, I think my client should be assessed for competency or criminal responsibility, those are in the beginning stages of a trial, the two things that the court is interested in. Are you competent to be here and assist your own defense? And then do you have a mental illness that causes you not to be responsible for any crime that's alleged? And so those are the ways in which, from the bench at least, you get started to interact and try to make some decisions about mental health. But even without either the prosecutor or a lawyer saying that, it is still the judge's responsibility to assess the mental health of a person in front of them. And as you can see, wherever there is some discretion, and it's just based on one person's decision making, you may get 10 judges and come out with 10 different reactions to someone who is in front of them. And these are the places at which we see people, as I call it, falling through the cracks, who aren't just accused of a crime or on one side of a lawsuit or other, but actually need more from the court. And it is a point of education for judges. Judges don't just step onto the bench and, oh, hey, now we know everything about every topic. Do not believe that. Judges are too learning the entire time that they're working. And even though I had represented people who were service members, I had prosecuted people who were service members, I had represented people who are civilians in Massachusetts, and I prosecuted people who are civilians in Massachusetts. I hadn't really had an opportunity to think about mental health within the system until I came onto the bench. And not only did I deal with it in cases where we need to assess someone, send someone for an evaluation perhaps for 20 days or 21 days, I also dealt with it in terms of having the responsibility of doing the things that Chapter 123 of our general laws requires, which are all of the commitments that are either voluntary or not voluntary that judges have to do. And that includes short-term commitments like Section 35s, where someone may have an acute substance abuse issue going on, or reasons that their family think they need to go into the hospital today, and I'm coming to the court to make that happen. It could be anything from that to a criminal case in which we're having an evaluation, or it can be someone who is already serving a commitment, and I have to address whether or not they are forced to take a medication, or whether or not they get something else like electroconvulsive treatment. And these are the things that just an average person may not have to decide about anyone else. And whether you have a personal experience with mental illness or not, being involved in the system in those ways causes you to have to really think about what is required for people to be better and what the state should be doing to assist them. And in all of these areas, there are people who are good at what they're doing and really helping people, and there are people who are not so good at what they're doing. And I think it is incumbent upon all of us to understand the intersection of mental health and criminal justice system, and understand what it is that the state can do and cannot do to assist people. The court-ordered treatments that you see attendant to criminal cases go a part of the way in addressing issues for folks who actually have convictions, have pleaded guilty, or have been convicted after trial. And these are treatment and evaluations that are a part of a sentence. And that, to me, has always fallen flat, sort of how do we do better? You know, it is such a large percentage of people who are before the court who either have mental health issues, substance abuse issues, or the combination of the two. And that is such a large percentage of the people who come before the court that we actually have created these smaller courts for drugs, drug courts, for people who are not necessarily the highest echelon drug dealer, but who are using drugs and are within that world caught up in being charged with crimes, but mostly need help and treatment. We also have mental health court. So we have all of these sub-courts and special divisions because the number of people in crimes, involved in crimes and being accused of crimes, have these issues attendant to the situation that sometimes explain it, mitigate it, or at least draw us to the conclusion that we need to be addressing those problems at the source, more so than just, well, it's this crime, that equals this many days in jail, because that obviously doesn't get it. And once we do put people in a situation where we are now completely controlling what they have as life resources, then we have to deal with how do we do better in that setting. You have a high percentage of people going into incarceration who are on medications, and they're not always for physical illnesses. Sometimes they are for mental illnesses, and you may be surprised that you can't get every medication in prison, even ones that are prescribed to you. And those changes refusals to provide medications that people have been on for long periods, imagine the harm that does and the turmoil that causes for the person now confined and the people around them and their families. And so these are just, little subsets of issues that all are revolving around this same axis. I want to not just talk at you. It's not a lecture, but I want to have a conversation and talk about these issues. These are just a set of the issues that the Life After Prison deals with, and it's literally organizations like this that really help people who are returning to our communities stand up their lives again. And of course, if you don't have health, you really can't do any other part of that. You can't work, you can't maintain housing, you can't deal appropriately with your family. You can't do anything if your health is failing, and that includes your mental health. And so it's literally these types of organizations that are doing the actual legwork to get folks the assistance they need, and not just general assistance, but assistance that is particularized and will really go far in getting that person back to a good baseline. And that's what we all need. Everybody is at some point off their baseline for some reason or other. Everybody. And those of us who need a little more help getting back, that is what we are working to help provide people, and that is one of the reasons that I am working with this fine organization. So I'm going to stop talking there about the court and my experiences, and allow any questions or comments if people want to have a conversation about how this interacts with the system, criminal justice or the court system in general.
So I'm going to have one of our LAP team members grab a mic up there. Mike, you want to grab a mic as well? We're going to take a few questions before we get into the panel discussion.
I think you've got one right in
And I've got
Patrice.
Oh, okay. And please introduce yourself.
Hi, my name is Thomas Combs. I did 30 years in prison, and as a fallen Marine, so I just want to say 75 to you. Thank you for your courage. Thank you for your willingness to stand up to the DOC, because I know how the DOC operates, and not just going with the flow and not kind of going, what they want to happen. So I just wanted to say thank you for your service, and thank you for all that you're doing with mental health, because it's very important. That's all. Thanks.
Thank you so much.
Thank you.
Real quick, thank you for your service. I was recognized as a juvenile lifer on my second parole hearing after serving 17 years. And then my next parole hearing was after 2021. But I was recognized as a youthful offender. My question to you is, at 17, do you feel that the mental health of being incarcerated with adults, charged and housed with adults, that there should be some mental health, acknowledgement or programming? That's the question.
Yes, thank you for that question.
How do we go about starting that?
That is, that's a really good question. And when I last visited Shirley with Mike and Patrice, we ran into a former client of mine who was very, very young when entering the prison. And he has become instrumental in starting programming for folks in his age group, realizing how different it is than serving time, like you said, with adults. And I think that as a society, we just lump anybody who gets in trouble together. So just throw them in there and throw away the key. We don't really care. At least that is the sentiment that I feel that people have about folks who get locked up for some reason. And it's part of the reason that it's taken us so long to realize how big of a detriment it is to a young person to be in that predicament, and how much it's going against what we want them to get out of being confined. It's actually doing the opposite. In terms of programming, the institutions have their own ability to start and expand programming, and so they have a budget, and folks within the system can start programming, but also if it is to be on a more mandated level for all of the institutions, it has to come from the legislature. And you know, how to get, I'm not a politician, but we can all look at, if you just look at CNN, you can see the things that get the attention of the legislature and when and why. Not necessarily every good cause gets the attention of the Congress, right? But that's what would have to happen, whether it's on a national level or more particularly here on the state level, getting the attention of our Congress people here to address this issue. And it's not that, you know, I don't think Massachusetts is the worst state in terms of its prisons and its entire system, but we're nowhere close to the best either. And so it takes a lot of advocacy, getting the attention of people who write proposals as to what the next bill should be, what the law should be, what changes should be made to the prison. You know, just to get the Criminal Justice Act passed, it took organizations working on behalf of prisoners, working on behalf of criminal defendants, different types of organizations coming together and saying this should happen. And here's the backup, here's the data as to why it should happen. And showing those detrimental effects that you're talking about is what will get that attention. And you know, there's not a huge appetite for making things better for people who are incarcerated. That just is the case. So you really have to sort of force and shame the legislature into doing it. But it takes a lot of advocacy and coalitions. You know, it can't just be the Life After Prison asking for this to happen, or Shannon Frison asking for this to happen. It's got to be all of us, and the ACLU, and Prison Legal Services, and CPCS. It's got to be all of us asking for it together. So it's kind of a big party that you got to put on and get folks behind it.
Thank you.
So my name is Matt Hudson. I work for Prison Legal Service, Racial Equity and Correction Initiative. And I wanted you just to kind of talk, and I know we're short of time, but I just want to I want people to hear just what type of assault that the DOC waged on you when you actually was hearing this case, when they challenged you, you know, for impartiality, and why do you think that occurred?
Yes, thank you. And I consider it kind of plain dirty. That situation that I described wasn't the first time that I have taken seriously a prisoner case. And on a previous occasion, up at Norfolk, had done a view, what we call a view, where I actually go and look at the spaces that we're talking about. In both of those occasions, the DOC asked that I recuse myself, either because I had tweeted something about an institution that was in the news, or because, as this lawyer put it, I was pro-decarceration, and so I shouldn't hear a prisoner case, which, you know, I didn't know I had to be pro-incarceration to judge the case fairly, which is basically how I responded and did not recuse myself. But pretty much since my walkthrough at Norfolk, they did not want me on any cases. Even though I left the bench, I haven't left the law. So they will still be hearing from me in a different capacity about those